Hello, everyone, and welcome to the third and final day of the Center for Democracy and Technology's sixth annual Future of Speech Online event. My name is Emma Alonso. I'm the director of the Free Expression Project at the Center for Democracy and Technology, and I'll be your MC for today. This year's theme, the Supreme Court's pivotal term, takes the important online free expression questions appearing this term before the US Supreme Court as the starting point for 3 days of discussions about online content governance, intermediary liability, and platform accountability, and what we actually want from the online services that we use and our broader information environment. On Tuesday, we heard some big picture perspectives about the questions the Supreme Court is taking on and what implications they might have for online speech and speakers in the US, and how online services approach content moderation. We also got an update from the Meta Oversight Board members about their latest policy advisory opinion that takes on Meta's controversial cross-check program. Yesterday, we took a deep dive into the laws and cases that the Supreme Court will be examining in Twitter versus Taamneh, Gonzalez versus Google, and very likely in the CCIA and net choice challenges to the Florida and Texas social media laws. Our legal experts discussed not only how the court might consider the specific questions before them, but also how its rulings could shape the ongoing debates around Section 230 and the First Amendment in the United States. Today, we're opening our aperture wider and talking about these cases in the broader context of online free expression debates that are happening around the world. We'll hear from Werner Steng, a cabinet expert on the Cabinet of European Commission Executive Vice President Margrethe Vestager, about the European Union's Landmark Digital Services Act regulation that could transform how online services are regulated across the EU and beyond. Then we'll be joined by a panel of experts to discuss the intermediary liability debates that are happening around the world and how the US Supreme Court's decisions could affect expression and access to information for people beyond the United States borders. And we'll wrap up with a final panel considering the debates around content interventions beyond social media services and whether it ever makes sense for different intermediaries to be considered common carriers. Some quick housekeeping before we get started. We are recording and live streaming all of the sessions on CDT's YouTube page, youtube.com/sendemtech. So if you've missed one of the fantastic sessions from the past 2 days, you can catch up on what you missed. We're also taking audience questions throughout the sessions. If you're connecting through the Zoom webinar, you can use the Q&A function at the bottom of the window. If you're following on the live stream, you can submit questions via email to questions@cdt.org or via Twitter @sendemtech, and across social media using hashtag CDT questions, hashtag FOSO2022. CDT's communications manager, Elizabeth Seeger, will be monitoring these channels and will pass those questions along to our moderators. We also have live closed captioning available through Zoom and on the live stream, and we'll be taking short breaks in between some of the longer sessions to allow our captioner to switch off. With that, I am delighted to introduce our first session, which is a discussion between Mr. Werner Steng, the cabinet expert for the Cabinet of European Commission Executive Vice President Margrethe Vestager, and CDT's own Asha Allen, who is our Advocacy Director for Online Expression and Civic Space at CDT Europe. Asha and Werner had to record their conversation in advance, so unfortunately they won't be available for audience discussion, but save your questions about the Digital Services Act for our first panel, because they can dive into those. Now over to Werner and Asha. Hi, everyone. Just bear with us for a minute. We are trying to figure out our audio issues. So we will be getting this video up and running with audio in just a moment.
So welcome to this fireside chat with digital expert to the Executive Vice President of the European Commission and Commissioner for Competition, Margrethe Vestager, Mr. Werner Steng. Hello, and thank you so much for joining us.
Hello, thanks for having me.
We're very pleased to have you. My name is Asha Allen, and I am the Advocacy Director for Europe Online Expression and Civic Space for the Centre of Democracy and Technology Europe Office. And today we're joining you from Brussels as part of our annual Future of Speech Online event. And we hope and are very sure that you've had an incredibly informative couple of days so far of events. But thank you for joining us for this conversation. So welcome to you, Werner. Thank you so much for joining us, especially at this very busy time for you and your colleagues. We are being joined by an international audience of stakeholders this evening. So if I could ask you to introduce yourself to our audience.
Yes, with pleasure. So I'm Werner Steng. I'm Austrian by nationality, work for the Commission. I've been doing digital stuff for more than 10 years. And it's exciting until today because, you know, I'm just witnessing what is happening out there, which affects all of us every day, whatever we do, and being able to help now also the Executive Vice President in conducting a digital business and guiding us through this digital world is a lot of fun and a privilege.
I would fully agree with you there on it being a lot of fun. And it's so brilliant to hear your profile. So you mentioned you've been part of this for the last 10 years. So I'm going to get into it because I'd love to hear some more from your expertise. And you have alluded to already working for the Executive Vice President. You've been quite instrumental in developing a key piece of legislation that may be generation defining, actually, in a sense, thinking about the changes in the last 10 years. And that's the EU's Digital Services Act, which has just entered into law. Some of us are celebrating this coming into law just in November. It's an ambitious regulation, of course, with potentially far-reaching consequences. So we wanted to ask you, as someone who was very much there and deep in the weeds of the process, could you run us through what the theory and approach of you and your colleagues were when you were drafting the legislation, particularly thinking about things as, you know, balancing provisions around illegal content and the preservation of free expression?
Yeah, with pleasure. Probably we really have to go back in time a little bit because the DSA did not happen overnight. Not that we woke up one day and said, oh, wouldn't it be fun to do the DSA? It's rather sort of the result of almost 10 years of work, if you want, on content related matters. Because when I became responsible for the e-commerce directive back in 2011, we already started to investigate some of the issues out there. And already back then, more than 10 years ago, it was around, obviously, some content that may not be removed quickly enough. But when we started to look into this, we found out that in turn, there was also a lot of content that should never have been removed in the first place. So that was really the first recognition of, oh, be careful here. You know, it's a two-sided issue here. Then while we continued working on this, in parallel, the platform economy became stronger and stronger. And with that also the influence that some players have on content moderation. So it was not just a mere issue anymore that there may be a hosting service provider that acts too quickly or not quickly enough. It was also that in addition, there was just a handful of companies that moderated all the content for us. So whatever decisions they took did not just affect individuals amongst us, but it affected societies and democracies overall. Right. So the longer we worked on those issues, the more complex actually the issues became, the more urgent it became to address them, and the more important it was not to make any mistakes when doing so.
Yeah, precisely. I can imagine there was a lot of pressure to kind of address those questions, especially around this last point on making sure you found that balance and not making any mistakes when you were doing that. And so were there any kind of specific challenges that, you know, come to mind when you think of drafting a legislation that was going to act in this very horizontal way that would try and strike that balance without making any mistakes? Were there specific challenges that you had to face?
well, many, of course, and as you can imagine, also lobbying was coming from all sides, which, however, also turned out to be an advantage, because it was not just a simple debate of a file where you have one position on the one end and another one on the other, but because every part of society is somehow concerned, people were sort of in their arguments balancing each other out, you know, and the more you listen, the more you learn, and the more you saw the multi-dimensions. The interesting thing was that when we put out our ideas for the DSA, we quickly saw consensus building around them about the main principles, and that was quite a relief and surprise. Because some of the obstacles, you know, was, can we keep the liability exemption, sort of the European version of Section 230 in the US? Or should we follow some stakeholders that said, oh no, that has fallen out of time, there's no justification for this anymore. Coming back to the large platforms of today, they are not just intermediaries, passive, but they make a lot of money with this, so why should they? So there was a basic decision where we said, no, hang on. It's very, very important, especially for freedom of expression and to avoid the surveillance internet, that we maintain this principle of limited liability. But at the same time, we had the idea we must also address the problems that those people legitimately want to address. Yeah? So we said, okay, let's decouple this from liability. And that was probably our strongest idea throughout the whole process. Let's just decouple that. We leave the liability as it is, but we impose other direct positive obligations on platforms to mitigate the risks that may be associated with their services. And I think that was the breakthrough, actually.
I agree with you that I think the due diligence chapter of the DSA in itself was what I think many refer to as like this groundbreaking characteristic of the legislation itself, and the very kind of two-pronged approach that you and your colleagues took when kind of trying to think about this in that very horizontal way. And so, of course, as now the legislation has entered into law, the next step is going to be bringing that to life. Do you have reflections on how the ambition of you and your colleagues will be best approached as we move forward?
Well, I think we are all up to a learning process here. This is not just any piece of law that now needs to be complied with, because it's very new to start with. It will operate in a fast-moving environment. And it contains quite some flexible elements and on purpose, because there may be other laws out there that are very prescriptive, right? And as a company, you wouldn't know exactly what to do to comply. You do 1, 2, 3, and you're fine. And the enforcers would have the same list of topics, you know, and everybody would agree on what needs to be done. We couldn't be as prescriptive here because the risks are evolving. They may be changing. In 2 years from now, you may find other practices on, let's say, social media platforms or on marketplaces that we don't know today. And the DSA contains some elements like this risk assessment methodology, where we say, well, if you're a very large platform, you have to assess year on year if there's any risk to fundamental rights, to illegal content, to disinformation, whatever it may be. And then you need to come up with credible risk mitigation measures. And then we have to look at that and the world with us to see, well, are these adequate measures? So there is, both for the platforms, the challenge of coming up with solutions that are effective and proportionate and meet the requirements of the law, and for us collectively to see whether this is indeed what needs to be done. So there's a lot of question marks, and we all need to learn collectively on how best to put this into music.
Absolutely, and I think it's going to be one of those learning processes that all the stakeholders that you probably engaged with during the development process are going to learn together and have an opportunity to contribute. But I did just want to draw on one thing that you mentioned there, and that was thinking about the other laws and what is happening in other contexts and what companies and others have to think about from a more global perspective. Now, you're in a fantastic position having being part of the European Commission that was able to help shape this. But as you, as an EU stakeholder, do you have reflections about developments that are happening globally? In the US, you mentioned Section 230, for example, that are related to some of the same areas that the DSA touches upon, and any kind of developments that you've seen that have piqued your interest there?
Well, quite obviously, what we are looking at are global phenomena. I mean, the things that we are addressing in the DSA are seen all over the globe, and they're also being discussed by many jurisdictions out there, right? The US, obviously, there's been discussions on Section 230 for a long time and whether it was still adequate and this and the other. But you also see discussions in Australia, New Zealand, in Canada, and elsewhere, in the UK, the Online Harms Act, and things like this, right? So discussions are taking place everywhere. So I think there's also, at least among the like-minded, let's call them like-minded nations, also an agreement that there is something that needs to be addressed. We may not always immediately agree on how that should be addressed, but at least, you know, as long as we all believe in the open internet and in the importance of fundamental rights and that we don't want mass surveillance. So if there's agreement on some principles, then all the rest is much easier. Now, when we discuss with the US, for instance, in the context of the TTC, which just happened again at the beginning of this week near Washington, we're not discussing the DSA or the DMA, but we're discussing all sorts of digital challenges together and to see whether we can find common solutions. Now, both sides on the Atlantic, for instance, would know that content moderation is a critical thing. Now, we can work on this and on artificial intelligence, on other issues together to see, okay, how would we want technology to be used in a way that doesn't undermine people's rights and values? So there's so much we can do together in order to also help companies, if you want, comply with our principles. Now, one side of the Atlantic may put those principles into law. The other side may probably not do that. But I guess we would all agree that the outcome of action of companies should be beneficial to our citizens.
Yeah, absolutely. And that's such a fantastic point on the agreement of the outcomes and the intent. I think it's what happens in the middle that may have slight differences in the approaches. Thinking about it from either a regulatory point of view or due diligence obligations point of view, but the intent and the outcomes, you know, as you're mentioning there, are aiming to be the same. So it's incredibly interesting thinking about those developments. And I often think that during the DSA conversations as well, there was a lot of reflection, especially amongst civil society, of how much the DSA would shape that global conversation, actually, because the EU was very much taking, and you and your colleagues were very much taking a step that I think many had been waiting for a very long time. And so there was some bated breath about how this would go and how this would be influential in that way. And so do you also see and have that hope that the DSA will shape a bit more concretely some of the confines or the lines of that conversation moving forward?
I seriously think it does. Because I think we have discussed this for longer and probably more profoundly than in other parts of the globe. And we see lots of people that come and talk to us from also the other jurisdictions, right? And saying, well, we're also working on online harms, this, that, and the other. Can you share your thoughts and experience with us, right? So I think everybody is very eager to learn from one another. It doesn't mean that everybody has to learn from us. We're very happy also to hear great ideas from other sides, right? But I do think that if we indeed can demonstrate that our law produces fair and balanced results, that there is a big likelihood that others will jump on the bandwagon.
So we absolutely share that hope, of course, having worked very closely with you and many others on the Digital Services Act, that of course that we have that very high hope for it as well. So lastly, I just want to come to you now that we're in the conversation of this international context, to ask you to share with our audience, many of whom may be policymakers, legislators themselves, stakeholders, what were your lessons learned and what advice actually would you give to other policymakers or legislators when it comes to establishing obligations, but also responsibilities for online platforms?
Well, that's a very big question. I think I already anticipated some of this in my previous answers. The first one would be that you really need to strike good balance. And in your due diligence obligations, due diligence does not just mean remove content. Due diligence also means make sure that content that is perfectly legitimate is protected, or at least that there are safeguards and redress possibilities and so on. So it's both sides, removal and over removal and under removal, if you want, that need to be looked at. Now, the other lesson that we learned was that that transparency is the starting point for all of it. Because when we were already 10 years ago looking into those phenomena of under removal, over removal, we always found out that we did not find out enough because the data was lacking. Why was it lacking? Because that was in the hand of some operators only, and it was under their control. It was their algorithms that decided what happened. It was only in their internal books that people knew what had happened. But the outside world didn't know. And then we said, oh my God, this affects society overall. It affects individuals, but it affects society at large. And yet, we don't even have information on what is happening to all of us. So that was in this learning point of saying, well, we need to bring more light into this. It's not just about the obligations on those platforms that do have control over the content. It is already to make what they do transparent to all of us. This is why we also open that up to researchers and not just to regulators. That's probably is also an important lesson that we felt we cannot on our own challenge some of the best equipped companies in the world, technically speaking, right? They have the expert. Not only do they control the systems and run the show, they also have the world's leading experts in terms of algorithms and data science and AI and what have you. So it would be very arrogant to think that now the European Commission or any other authority comes and says, we will be checking your algorithms, right? So we decided we need to crowdsource this as well. We need to open up those closed systems, create entry points for researchers, for organizations, for civil rights organizations like yourself, to come in and see what is happening to content. So that's why I'm coming back to this. We should collectively learn, but this is only possible because we have opened up this window into something that didn't have windows until today.
It's so interesting because I think some initial analyses of the digital services that's kind of quantified it as this data gathering machine, this legislation that was going to help us gather as much data as possible so we could make those steps and do the kind of collective learning that you're talking about here. So it seems to me it's always useful and beneficial to think about it in that global and international context, because we have to do that collective learning in that specific way. And so that's so interesting. For those of you who have joined us with the DSA now into law, but it is of course the first step. It will be coming into fully force in the beginning of 2024. So we still have a little ways to go, but it's been fantastic to be able to speak with you, Werner. Did you want to share any last thoughts or comments for our audience today?
Well, I think that my key message and wish is always for democracy at the end of the day to prevail. I think we are all concerned by this, and that's you, and that's me, and that's my kids. And I just want all of us to be empowered in our society, be able to control what we do, what happens to our data, know what we see, why we see things. It's just some very basic things, that many of us may take for granted, and probably my kids have never asked themselves those questions. But I know that they may not always see what they should be seeing. And so I think it is really important for us to benefit from this wonderful internet, which has brought so much to us. So we need to protect it, we need to cherish it, and make sure that it follows democratic principles.
protection and founded in democratic principles. I couldn't have said it better myself. Werner, thank you so much for joining us today. It's been amazing speaking with you. Thank you so much.
Thank you and have a good day.
Thank you.
Werner and Asha, thank you so much in absentia for that really thoughtful discussion. To continue the conversation about how intermediary liability and platform accountability discussions are faring outside the United States, I'm delighted to introduce our next panel, which will discuss the global implications of the US Supreme Court decisions and things not having to do with the US Supreme Court at all. We're so pleased to be joined by David Kaye, who is a clinical professor of law at UC Irvine and the former United Nations Special Rapporteur on the promotion and protection of the right to freedom of opinion and expression, a role that he served in from 2014 to 2020. David will be moderating this upcoming discussion. David, welcome, and over to you.
Great, I'm just trying to turn on my video here. All right, I'm here. The marvels of modern technology. Hello, everybody. It is great to, well, I don't see you all. I see Daphne, but we'll see the panelists soon. Everyone else who's on the panel, please turn on your videos now. We'll get this started. I'm really excited to kind of moderate this conversation. Over the last couple of days, of course, CDT, and I want to start by thanking CDT for organizing this amazing set of conversations, at which I know that people around the country and around the world have really learned a lot about the current situation in U.S. courts related to social media and the regulation of internet space moving forward. And thank you especially to Emma Lanzo, who is such a hero to freedom of expression advocates in the US and around the world. We have an amazing panel. And I think what we're going to try to do in this discussion is in a way to pivot from, although we'll still talk about the way in which the cases, Gonzalez, Google, and Tomna, Twitter, and net choice and other sort of laws that we're facing in state courts, the way in which they address kind of a situation for regulation within the United States. But this is a panel that can really speak to the implications globally. Not only the way in which these particular outcomes might have an impact, a direct impact on the way platforms think about these issues around platform governance, but also what can we expect other states to do? What can we expect other governments to do in response to the kinds of actions, decisions, determinations that we might expect in the United States over the next several months? So for this discussion, I'm not going to do lengthy introductions. I think many of you will know our panelists. They're well known in the space of discussions around internet governance, content moderation, and the promotion of freedom of expression and other human rights online. And you can also go to the internet, this thing that we all use, in order to learn more about them. But let me introduce them very quickly. First, we have Daphne Keller from Stanford University. We have Javier Palero from Access Now, who I think is based in Argentina, maybe joining us from Argentina right now. Fariha Aziz from Bolo B, a co-founder of Bolo B, joining us from Pakistan. And Chinmay Arun, who is the executive director of the Yale Information Society Project, and I believe is joining us probably from New Haven today. So it's great to see you all. We're going to start with a kind of a short overview that Daphne's going to give us of some of the key legal questions that are presented by the cases, and then we'll launch into a conversation, and later on we'll open it up to Q&A from everybody, which I believe you can use the webinar chat in order to submit your questions. So let me first turn it over to Daphne, joining us from somewhere in the Bay Area today.
Live from San Francisco, this is Daphne Keller, and I'm going to give an overview of these US cases, which I think some people in the audience are very steeped in, but others are not. I will try to keep it short. So globally and in the US, for the history of intermediary liability questions, the most heavily discussed question has been about when platforms should be legally responsible for content their users post that violates the law. When should they have to take things down? And you see globally kind of the same questions, the same policy and logical questions emerging about this everywhere. You know, so how can you devise a law that avoids a problem of platforms removing too much or removing in a way that has disparate impact, et cetera, if you put liability on them? Increasingly, in the past few years, we have seen the emergence, again, globally, of the opposite question, which is, are there times when the law should compel platforms to leave things up, when the platforms should not be given the discretion to take down content for violating their rules or policies or terms of service? And that claim you see formulated, or the policy logic of it, is about the biggest platforms operating as something like a modern public square or a utility or a common carrier. And that has come up in litigation in Brazil, in Italy, Germany. You know, it is by no means unique to the US. So we now see very likely both of those questions coming to the US Supreme Court at the same time for the first time in the entire history of the internet, that the Supreme Court has considered the liability of platforms for third-party speech. That was implicit in our seminal First Amendment internet case back in the 90s, but the squarely presented CDA 230 question and platform liability question here is truly novel. And unlike courts in a lot of the rest of the world, these guys have never thought about this. It's their first crack at this entire very complicated question, and they have a lot of opinions of the sort, or some of them are known to have opinions of the sort you might hear from pundits on TV or see in op-eds, but they don't have the depth of legal background that probably a lot of people in this webinar do. So the first two cases to be aware of are the net choice cases. These ones have not yet been granted review, but are expected to be granted review. They are about carriage obligations, about treating platforms as common carriers and forcing them to carry content they don't want to. Two American states, Texas and Florida, both enacted state laws with some form of carriage obligation so that there are things, hate speech, for example, or disinformation, that platforms might want to take down but not be able to. They both also have transparency mandates. And we can get into the details of those laws if people are interested. The platforms challenged both of those laws, saying it violated their First Amendment rights to set their own editorial policies. The platforms prevailed on that argument in the first instance courts in both cases. And then on appeal, the two cases diverged and reached opposite outcomes, with the 11th Circuit siding with the platforms and saying Florida's law violated their constitutional rights, except for the transparency provisions, which it mostly upheld. And the 5th Circuit saying Texas's law was just fine and was actually an anti-censorship measure and had no problem under the First Amendment. So we're at a stage right now where the petitions for Supreme Court review are still coming in, but it's widely expected that they will hear those cases this term, meaning that the ruling would be out by June-ish. While everyone was tracking those, suddenly out of left field came the news that the court had agreed to review two other cases about the more traditional platform liability question of when platforms can be held legally responsible for unlawful content on their services or for harms caused by content on their services. Those two cases are the Gonzalez case and the Tomnick case. And they both build on a very similar set of facts, really sad, terrible facts, and ask really similar questions. So they're both brought by the families of people who died in ISIS attacks, and they are both premised on the idea that platforms like YouTube or Twitter or Facebook should be liable because of the ISIS presence on the platforms at the time, And specifically because recommendations, like YouTube recommendations or ranking, like the ranking on Twitter, contributed, the theory is that the ranking itself contributed in a way that should be a basis for liability for the platforms, even if the content itself is, even if they're immunized for carrying the ISIS content itself. It's you promoted it, your algorithms spread it more widely, therefore you should face liability theory. The two cases raise the two versions of the question. One in Gonzalez is the question about how the statutory immunity under CDA 230 should apply. And so the claimant's argument there is that CDA 230 only immunizes the hosting of content and does not immunize the platform's independent action in recommending the content. Of course, a downside of that theory is that if you accept it, then all of the known problems of excess of liability on platforms, namely that they go overboard in removing too much, remove too much in a way with disparate impact, or stop making removals at all in order to avoid liability. All those problems just crop up in the news feed, in the ranked part of the platform, which is the part people actually use. All of the problems CDA 230 was intended to avoid would suddenly reappear and sort of change everybody's experience of the internet. So that's Gonzalez. It's about the CDA 230 immunity. Tomna is about if there is no CDA 230 immunity, then what is the platform's liability under the Anti-Terrorism Act? And so this is a question that will be familiar to people who have seen cases like this litigated in other countries. That's asking, can the platform be deemed to have knowledge in a situation where it took down every ISIS post it was aware of and every ISIS account it was aware of, but they had been told there was more out there and maybe they could or should have gone and done more. Can you call that knowledge as the mental state for liability? And then secondly, did they commit an act of substantial assistance? So it's a question about the mens rea of knowledge and the actus reus of substantial assistance, both of which you will recognize if you have seen cases in places like Argentina or Germany or India, where a lot of questions like this have been litigated in a way with useful outcomes that it would be nice for the Supreme Court to pay attention to. And maybe somebody will write a brief urging them to do so. I'll stop there.
That is a perfect segue, Daphne, to bringing in the other panelists that we have here. But I want to thank you for that overview. That was amazing. And I think the key point, there's a number of things to pull away from that, but the fact that we are now looking at the Supreme Court engaging both on sort of the regular traditional content moderation questions about liability for content that exists on the platform and common carrier or must carry obligations is really remarkable. And I think you've just highlighted how come June, we could be living in an entirely different legal framework because that really captures the field. Both of those issues in so many ways. So thank you so much for that overview. I want to turn to Javier and allow us to sort of think about those kinds of issues, and also maybe there are others that you're seeing and that our other panelists are seeing in different environments around the world. So for now, what I'd like us to do is spend a little bit of time just highlighting in a few different areas the kinds of regulatory moves, pressures, however you want to think about them, in different environments. And then we'll talk a little bit about the way in which the courts in the US interpretations and decisions might actually have an impact on that. So let's start with what's happening in the area that you tend to focus on, and whether in Argentina or more broadly in Latin America, Javier.
Well, thank you, David, and thank you, Daphne, for the great summary. So I will try to focus on the Inter-American perspective, and I can give a specific example of Argentina, particularly from a very recent case that starts to see beyond the initial interesting precedents that Daphne mentioned, well, this is the not so interesting twist or that interesting precedent, right? We can have nice things in Argentina. Someone has to break them. And now the court has done exactly that. So let me go by parts. From my perspective and from more of an Inter-American perspective, the first things that comes up for us is that this is something that we had been expecting, because the general interpretation about free expression regulation and the safeguards that the state has to provide for free expression accept and actually incentivize more governmental intervention, something that in the US context is very hard to think about in the classical sense, right? So, for example, in the Inter-American Commission understanding and in the doctrine of the Inter-American Court, for example, concentration of media is equivalent to quote unquote indirect censorship, right? So this is the strength with which the system calls, the institution of the system calls the aspect of excessive concentration, right? And that comes up and adds to the history that we have of more intervention in order to generate in the public interest, right? So, for example, giving the right to reply, or establishing that law can force certain TV channels or radios to just, have public interest content, like electoral publicity, for example, or advertising. So all of that comes together with this legacy idea that for us, a certain level of intervention in the public interest is good and it's expected. And on top of that, the issue of concentration generates even more scrutiny on this. So the current situation of platforms and how they work in practice in regions like in Latin America bring these questions up very clearly. So these are already being discussed. Several of the regulatory ideas that we have seen, for example, the Montreal bill in Mexico last year, or the latest regulatory attempts in Brazil, or also bills in Argentina and Chile, have this rationale in mind. There's too much concentration, there's too many decisions that are not transparent, and the public impact brought by the dominance of these platforms brings the attention to actually what we should demand from them, and also about how much they can control of that speech. Because again, there's also the technical element that the internet of the 20 years ago, right, the level of granularity to which you can take data points and recommend content, and what can you use as a variable there, what kind of harm can you detect and prevent, was different from now. Now the technology is way beyond, right? And can enable more manipulation in the sense of like choosing what to show, but also maybe choosing what to maybe stop or hinder, right? So this idea of harms, for example, this very nebulous idea of harms, is basically a compound aspect of several things that have to do with curation or recommendation, right? But that calculation in the times when Section 230 was born is different, where maybe like an editorial decision was made by a human. Now is very different in scale and in complexity. So I think this is a very interesting point. And just to finalize, lately, for example, the De Negri case, Natalia De Negri case in the Argentinian Supreme Court brought up the idea that, okay, we have a limited liability in the model of conditional liability, meaning that when you have actual knowledge of something, you are liable, basically after a court order, with one exception. But now the court, in an obiter of the decision, said that we need to look at how actual knowledge would work in the case of recommended content, right? Because it's hard for them to think, and also for several of us in the space, to think how you cannot have actual knowledge of the very clear consequences of algorithm recommendation, right? So I will stop right there, but that's pretty much the initial take that I can give from the regional perspective.
Javier, that was really great. Can I ask you a quick follow-up? Daphne mentioned the fact that the cases coming to the Supreme Court are sort of the first opportunity for the court to address these issues. And I wonder if, and so that of course leads to the situation where, and we've seen this, I think, at lower court levels as well in the US, where it's new, there's not a lot of experience of the judges in working on these issues. And I wonder if whether in the Inter-American generally or in the Argentinian context, there's a different experience. In other words, how do you evaluate the court's expertise on these issues that are, frankly, I mean, at one level, they're not complicated. They're sort of straightforward legal questions. But on the other hand, they deal with some differences in technology that might be new to some of the members of the judiciary.
Yeah, I would say that there's a lot of expertise in several countries, and particularly in the Inter-American system, about freedom of expression and media regulation in general. But when it comes to the internet and its particularities, much of the narrative is still stuck in the debates of like 5 or 7 years ago, right? When there was this more, let's say, classic liberal approach to free expression, in the sense of like, let's don't touch the toy, let's not break the toy, right? But right now, everything has shifted toward moving to following the European developments for the good and the bad. Like the Piaczek case, for example, was really made noise in this latest case that I just mentioned, the Argentinian Supreme Court. But I would say that there's preparation on the classic principles and on the basic ideas, but as I just said, sometimes the extrapolation is not very positive or very straightforward. So we have to pay attention to that.
Great, thanks for that. That's really interesting. So I want to turn to Fariha next. Fariha, obviously, Pakistan has been engaging in attempts to regulate online speech, both through normal regulatory processes, but also through the kind of extra legal processes that we've seen that have really hit human rights defenders and journalists hard over the years. And I wonder if you could speak to us or speak to the situation, particularly from the regulatory side, but also the general questions that we started with when Daphne was highlighting these questions, on the one hand of content moderation and the other must carry obligations. Obviously, those are part of the same basket, but how are these issues playing out in Pakistan?
Thank you, David. So we're facing a problem, one with content moderation on the one hand, and then the move against dissent and regulatory regime is not just content blocking or moderation, it's also criminal cases against journalists and dissidents. All of this is housed under the regime of the cybercrime law, which was enacted in 2016, the Prevention of Electronic Crimes Act. And in it, several speech offenses were created for the first time. And the law enforcement was given jurisdiction over what is posted via social media or the internet. And we've seen a lot of cases where there's criminal defamation, hate speech, cyber terrorism. All of these offenses have been applied to legitimate protected speech. And that's only become apparent after some of the cases have been quashed through court, which has been an arduous process for people, but it has had its chilling effect. On the other hand, the liability protection, a limited liability protection, is also housed within the ambit of this criminal law. So, of course, while the language says if a service provider has actual knowledge, willful, etc., but we've seen that the way service providers or platforms have been held to account outside the law. From the time when YouTube was banned, for instance, for 3 years in Pakistan. So it's essentially the approach has been by the regulator, by successive governments. If you do not take down what we tell you to take down, we're going to shut you down for an indefinite period. And this is something that they've been doing. And so when it's been challenged before court and the courts have responded somewhat positively to these challenges and created checks and balances, what they go and do is, well, if the court's checking us, if they're telling us there's no law, it's illegal, let's put it in the law. And so that's how the regulatory model. So we have the freedom of speech section is housed in Article 19 of the Constitution of Pakistan. However, the way it's worded, there are very subject categories and restrictions. So even if it says reasonable restrictions imposed by law, there's decency, morality, national security, friend relations with states, really vague subject categories. Now, while this is the ambit of Parliament and the judiciary, Parliament to legislate further, like we have with Article 19A, which is right to information laws, which lay out a process. What do you have access to? What do you not have access to? What is the process? So Article 19 was copy-pasted into the cybercrime law into Section 37, which essentially, in a very overbroad manner, give the regulatory authority, which is the telecom authority, judicial and parliamentary powers in the sense that they say you can apply the restrictions in these subject categories, then we saw the social media rules in 2020, and these were introduced. These rules went even beyond what the law permitted. So the law does not say you can carry out blanket bans and there are due process requirements. Those are regularly flouted. Then instead of an oversight mechanism over the authority, how they can exercise powers, obligations are created for social media platforms. And this is something that even the law doesn't specify. So through through subsidiary rules, subsidiary legislation, they introduced this. So there were timeframes. For example, an emergency request can be 12 hours, and a regular request could span between anywhere 48 hours. If the platform does not take it down, the rules say that they can take action. The regulator can take action. They can block the service. They can degrade services, etc. They've also put in requirements for content moderation, for introducing AI. There have to be content moderators. In addition to that, they're saying open offices, appoint staff, and they say that community guidelines fall below local law. So local law takes precedence, and the social media platforms must make users aware of local law requirements. And local law is also vague, and local law is also applied in an overbroad manner to restrict speech. I'll give you an example. In the Google Transparency Report, we saw that there was a request by the PTA about a letter that was circulated by academics about shrinking spaces in universities. And that was reported under Section 11, which is hate speech of the cybercrime law. So these are some of the ways in which they send overbroad requests. So we have powers, you need to take it down. And the approach still is that when we tell you, it's not about a piece of content, some content, it's every piece of content that the regulator says you take down, you need to take down, or you will be shut down, or we will take adverse action against you. And this is essentially what we're seeing playing out, one on the moderation side and regulatory front, but more concerningly on the criminal cases that are filed, which are really, really difficult for people to fight against.
Oh, thank you for that, Priya. If I could also follow up as I did before, that was really interesting. And it seems like what Pakistan has set up is a fairly blunt approach to the platforms, and in some ways kind of binary, right? I mean, it seems very much focused on, if you're not doing X, this thing will happen to you. You will be blocked or throttled or whatever might be the case. And I wonder if you could tell us a little bit about the relationship, to the extent there is one, between the major companies and the government. In other words, in a situation in the United States, for example, there's kind of close relationships, there's obvious jurisdiction over the companies and so forth. How does that play out in Pakistan when we're talking about like threats to companies, but the companies, or maybe a handful of employees, may be localized, but generally the companies are far away?
So this is actually the approach that they're taking is something that they've been familiar with, where the telecom sector, where there is a physical legal presence, they're incorporated here, they have staff on ground. And similarly with the electronic media model, where they are licensees. And so there are licensing conditions, and social media or internet is different, because, and this is a debate that's played out from the time of the YouTube ban, because we don't have the presence, unlike, let's say, India or Turkey or other countries in the region where they're incorporated, etc. But they just seem to think that we can borrow and pick from certain regions, that we can make them come here, which is why the obligations have been laid out in the rules. You have to open an office, you have to put staff on ground, because they know that when that happens, and this is something that's played out in the telecom sector with the electronic media, the switch on, switch off switch, there are ways to pressurize. Extra legal measures, as you mentioned, we know that people get picked up. There are phone calls, and on the basis of that extra legal pressure, there's compliance, and there's compliance otherwise, because then there is a risk of your license being cancelled. And we've seen that with the electronic media channels, etc. So that's the approach that they've harbored towards social media platforms or the internet. However, what they don't realize is they're not here. And so which is why the Asian Internet Coalition responded the way they did, because they said, we're just not going to enter. So the difference with Pakistan is they've not entered your market. formally. Of course, their services are available. And so to the extent that blocking of service happens, but all of these other things that are happening to other sectors, there's a real fear that it is going to happen. And not only because it's not just about content moderation or criminal cases. There are data provisions that have gone in here. They want servers to be brought here and established here. They want data handed over as and when. So they're sort of mixing up all of these regimes. We don't have a data protection law. We obviously don't have a rule of law regime. We have some level of checks and balances by courts. But otherwise, it is a lot of extra legal pressure that is applied to gain compliance, and then whatever regulatory leeway there is in terms of, again, coercive power. Or we can fine you, we can cancel your licenses, we can harm the people that are on the ground. So you need to think through and then comply.
Great, thank you so much for that. So let me turn to Chinmay. Chinmay, you have a global outlook on all of these issues. Being at Yale and with the ISP, you obviously have a kind of a perspective that gives you a sense of global trends. And of course, also expertise in trends in the US and in India and in other places. How do you see these issues playing out, maybe in a majority world context or more particularly in an Indian context? How are these similar kinds of issues playing out there as well?
Thank you, David. I'm going to pause to thank Emma for inviting me and for being patient with how long I took to respond, and Daphne and Emma for all the brilliant background. I had two broad reactions to Daphne's excellent provocations, and I think that they come a little bit from everything that I have learned from everyone on this panel. One is that I feel like this whole the US-based legislations, depending on what happens with them, the must-carry rules, are actually rules, I don't know if I'm being naive, but they're rules that I would be concerned about if I were outside the US, because if certain kinds of content have to be up on platforms and platforms are not allowed to remove them, the question is, what happens when that kind of content incites violence or results in what some might call terrorism in other jurisdictions. And so it's going to be interesting to see, firstly, what happens with that, but also questions the justices will take into account that there will be implications elsewhere. I imagine that if they don't, the platforms will have to come up with new ways of regulating. For those of you for those who are watching who are not experts, so far the way the platforms have cut it is that they've got their own rules for removing content like this that is potentially harmful but not necessarily illegal everywhere. And if those rules are if the platforms are prevented from keeping those rules in place, as these legislations are attempting to do, then they'll probably need a different system for protecting people in other countries. Now, so far as I know, their geo-blocking has tended to align with local laws, the way Faria was pointing out. So far what's happened is that if a particular form of speech is illegal or criminal in India or Thailand, and sorry, the panelists know this is for anyone who's watching who doesn't, it would be geo-blocked over there. And I wonder whether there'll be a creep of that function if the platforms feel that it becomes necessary in view of these laws, taking a very, very pessimistic reading of what might come. But I think that the second and third questions that I'm thinking about are more interesting, which is that I think that it also results in everyone asking the question of what is terrorism? This is the second set of cases that Daphne was discussing, Gonzalez and Tamne. And once we're discussing terrorism as defined by states, and I'm not talking about ISIS or any of the easy cases, I'm talking about states that would choose to categorize what some people might call freedom movements as terrorist movements, then I think that the same stream of legislation starts taking a different color. And I think that that's again, more broadly what's happening here is it's creating a trend, in my view, which is that courts are correctly questioning, asking the question of, do platforms have too much power? I don't think that anyone here would argue that they don't, but I think that the answers that different states are giving vary. And if we think of this as potential regulatory creep, that some states say that, okay, platforms will be held liable for enabling terrorist content, and then that states will decide what terrorist content is, or that states can choose to take a broad reading of what terrorist content is. I think that that's going to lead to a different world almost for freedom movements. Not that they've not been under pressure already. I think that we've already seen trends where states are pressuring platforms to remove content that is essentially protest content. And one of the ways in which they're doing it is categorizing it as potentially violent and anti-state content. So I think that these developments, when I read about them, I'm like, they look like they could end up legitimizing a lot of fairly disturbing practices. But I'm not sure how we would push it back unless there is a clear definition of values that states and platforms need to align behind in this context. And we're sitting with David Kaye, who has offered us several ways in which international human rights could be used to build these values. And I think that there's never been a greater need than before in saying that we have to caveat these kinds of regulations, as opposed to framing them in a way in which we're saying that states can come up with them in response to what I freely admit is a legitimate question. I'm not sure if that was articulate enough, but that's my reaction to this.
No, that was great, Chinmay. And maybe I could follow up because I think this last point you're making is so interesting, and tie it to the context in India, just as an example of this. So in the context of the spyware claims, the Pegasus claims that have been brought in India, the Indian Supreme Court essentially pushed back on this notion of the government having kind of a carte blanche to say, oh, this is national security, therefore we have the power to do something, which was very interesting. I mean, it was very interesting for the court to do that, and kind of a hopeful thing in many respects. I wonder if you can imagine that same kind of pushback in this context as well, whether it's, defining terrorism, defining, as we've seen Modi's government do, defining dissent as contrary to national security. Do you imagine that also being a kind of pushback so that there might be some protection in an environment like India or other places?
I think the questions that I would be inclined to ask if I were being paranoid would be, how would people treat the Kashmiri freedom movement? I often get emails from platforms sending me videos saying, why exactly is this terrorist content? And usually that video will contain something about the violence in Kashmir that is faced specifically by Kashmiri Muslims. And the Kashmir, interestingly, is almost a laboratory setting, because what's happening there is the extreme version of anything what was happening in Kashmir 30 years ago was things that couldn't be contemplated in the rest of India. And so when we're being sent videos about Kashmir, we're being shown a very fraught relationship between the state and citizens. And these videos are about freedom fighters, and they're highlighting how dangerous it can be for these people. And they're showing extrajudicial killings. And so I think that is basically what I would think about if I had to present a hard case of how does a state weaponize terrorism laws against a freedom movement. I think Kashmir is a classic case, but there was also a period, and again, not to interfere with your optimism, David, it is a good thing, but there was also a period in which there were these farmers' protests going on in India, and protests against citizenship laws. And the platforms were having, what I gathered, were very tense conversations with the government. And picking up from Faria's brilliant laying out of the problem, it's interesting because different states also have different levels of power with platforms. And I think if we move to this new world that I think is looming, where platforms say that, okay, fine, we will just accept what each state chooses as its definition of illegal and terrorist, I think that it might lead to consequences for groups of people that don't necessarily agree with how their particular state defines these questions. And that's what takes me back to, well, if arguably the democracy isn't as functional as most people would hope, or if it functions in a way in which there are minority groups that are completely cast aside, then what does this new generation of regulation mean for them?
Great. Thank you for that, Chinmay. That was great. Obviously, we all want to be optimistic, and I presented, but it was a really helpful response, and I think realistic as well. Okay, so there's one more region that we haven't addressed yet, and I want to turn to Daphne. If you could say a few words about what's happening in the EU. Obviously, to encapsulate everything that's happening in Brussels, given the fact that on the regulatory front, Brussels has been incredibly active over the last couple of years, from the DSA to the DMA to AI and so forth. How would you, like in just a few minutes, that's the challenge, encapsulate sort of what's happening in this respect in Europe, and of course beyond the EU, because I know you've looked at cases out of Germany and other places elsewhere that have kind of taken the lead on some of the must-carry kinds of questions.
Yeah, so I mean, there's a lot going on in Europe. Very, big picture, I think of it as GDPR for privacy, DMA for competition, DSA, Digital Services Act for content. And I'm going to talk about the DSA, but don't anybody make the mistake of thinking they're done. There are a bunch of other complicated and really problematic laws being proposed right now. But the DSA, as Javier mentioned, is being looked at as a potential international model. So that makes it particularly important. And in many ways, it's not that bad. We could have had some much worse international models. The DSA was restrained compared to a lot of proposals in the US and around the world. It did not enact must-carry obligations. It did not enact new general monitoring obligations to go out and try to filter things. It did not enact new rules limiting distribution of lawful but harmful speech. A bunch of the big troubling ideas that are in instruments like the UK Online Safety Bill, for example, are not in the DSA. So that is the good news. The more mixed news, I think, both of the big buckets of obligations in the DSA have mixed consequences for other parts of the world. So one is just that the DSA, sorry, this is neither of the buckets. One is that the DSA, like the GDPR, has very grabby jurisdiction provisions. So it will apply to a lot of platforms, including very small ones outside of Europe, with potentially, in theory, very, very high monetary damages, and with obligations that small platforms are never going to meet, like having a paid representative on the ground in Europe with the capacity to take things down and respond to court orders and things like that. So there's just, there's this looming omnipresence of getting in trouble in Europe that I think is going to be anxiety provoking for a bunch of companies, small companies around the world that just kind of can't do anything about it. But for countries that are looking at maybe emulating it, the big buckets are first a set of new procedural rules and second a set of new regulatory rules. The procedural rules are making notice and takedown much more protective for users, ensuring that they're notified when content gets taken down or restricted in visibility, ensuring that they can have appeals, ensuring that there's better transparency. A lot of stuff that civil society has wanted forever, that I've asked for forever, and now I'm a little bit switching sides because I think that the degree to which the DSA wraps every single platform action in this thick layer of administrative obligations, including for platforms that only have 50 employees, for very small platforms, I think is really going to contribute to entrenching the incumbents and is trading off competition goals for these extensive content regulation goals. I have a chart showing which sized platforms have to comply with each of the DSA obligations. I will paste it in the chat once I'm done. So that's the sort of procedural part. But I think for people in many parts of the world, that would be an improvement on what they might be seeing in national legislative proposals. The other part is for the biggest platforms, they will have this new, very extensive and ongoing regulatory relationship with the Commission and also with new national bodies within member states called digital services coordinators. And they will have to produce annual risk assessments, annual risk mitigation plans. Then the regulator can tell them if they didn't mitigate the risk right, so they need to do something else. They have to do audits. And they have to participate in crisis protocols to take content down on an urgent basis under terms that are distressingly TBD. And I think, from talking to people, actually, honestly, specifically in Latin America and South Asia, so we have other panelists who can really speak to this. I think there is a lot of worry about putting those kinds of powers in the hands of regulators rather than courts in many parts of the world. And so that aspect of the DSA, if you are in a country where lawmakers are thinking about emulating the DSA, I would pay attention to those parts in particular. I have more to say. I would love to follow up on Chinmay's point about jurisdiction, but I'm conscious of time, so I will hold that for later.
Well, if we have time, let's go back to that. And I want to also highlight to everybody who's watching, please share a question. If you want, we could probably go for several hours with the number of questions that I have and that I think panelists would have across the panel. So, but please feel free to ask your questions. I want to kind of pose this question in a way. It's taking off of where Daphne just finished. There's two kinds of models potentially that are out there. There's a kind of DSA-oriented model with its, risk assessment, digital service coordinators across Europe, and this, we don't know yet how intense it will be, but conceivably intense scrutiny over platform decision making. That's sort of set against what might come from the Supreme Court, which could be more sort of blunt opening up of liability for a range of content decisions, whether we're talking about takedowns or must carry and so forth. And I would love to hear from Faria, Javier, Chinmay, like which of those models cause you the most concern given the environment you're in? Because I think that it's almost certain that just as with the Network Enforcement Act in Germany, NetzDG, and how it had a kind of global impact or certainly impact in the neighborhood, I think we could see that happen with the DSA and others. So I wonder where your concerns mostly with respect to these global models. Maybe I'll go to you first, Faria.
So because we're a common law jurisdiction, and often when we talk about speech and when we cite the US example, we're told, don't talk about the First Amendment, it's not applicable in our context, right? And then you have to also contextualize because there's some misperception as though it's complete free-for-all, absolute, there are no speech restrictions, exceptions, even in a jurisdiction like the US. But what's happening in the US, and especially the DSA, because a lot of these things we're seeing in the social media rules. We've seen in the data protection bills that they've copy-pasted from the GDPR, but something that Daphne mentioned as well, right? The size of a company. If it's a 5 people, 10 people, 50 people company versus a larger, there's no distinction between how much human resource, how much monetary resources can you put towards, in terms of the obligations that are being created through certain laws. And we are a country that is heavily, heavily regulated, and they go beyond the language of the regulation as well. So obviously, but then to Chinmay's point, we're also looking at an internet with borders. So that even the global platforms tend to comply with local laws in different ways, and that plays out differently within the country, and which state has how much pull over a platform depending on various factors, but then regionally how it plays out. right? And we see this. I mean, Chinmay gives the example of Kashmir, but also, for example, between India or Pakistan or Palestine or other conflict zones. And so whether somebody is categorized as a dangerous individual, even from a journalist perspective, if you're on Twitter and you're quoting to condemn, oftentimes you'll see that you've been reported or it's been flagged as a violation, but how do you comment on something? How do you say this is wrong without referring? And so these are things that we're seeing play out on the moderation side of it. However, we understand this as a real world harm. Whether it's, their marginalized voices who are either being driven off platforms, they're real threats, you need turnaround times. And that's also something that you're looking to platforms to do, but that's not necessarily happening. And then the regulators and the government and even courts, for instance, step in, sort of this elephant-footed approach, right? That you have to do this. And as Daphne said, we'd like some of these things for courts to resolve, right? And not just overbroad powers to regulators, but over here, for instance, in our context, the courts that we're already overburdened, the executive comes and says, it's instant, it's terrorist content, it has to be done urgently, we can't wait for a court order. And those narratives are exploited very easily, given that there are certain on-ground realities and situations. And it's a difficult space, I think, to be in globally now, where we have to find balance between resolving harm, but what is the adequate way to do it? I don't know if there are answers. We're all looking for answers, I believe. There isn't a perfect solution out there.
Great, thank you for that, Priya. Javier, how about you? What do you see as between these, and these aren't mutually exclusive, of course, but among these different possibilities, what concerns you?
Well, what concerns me are the intended solutions that don't consider several other aspects that go beyond the merely regulatory, meaning political realities, institutional strengths or weaknesses in regions, economic pressure too, and concentration in other areas such as the telecommunications area or the legacy media area. So, for example, the nightmare model, in my opinion, in Latin America would be the one that gives administrative authorities, particularly legacy telecommunications or media authorities, power over this. I would stick yet, even with this gap that I mentioned before, with the judges, right? Instead of excessive or very wide powers to media authorities. For example, remember that I said that there's a very rich jurisprudence and doctrinary work around free expression and exceptions and inclusivity and indirect censorship and so on, but all of that doesn't work either, because there's a huge deal of regulatory capture in the administrative regulators around several countries in the region. The legacy of military dictatorships and the strict control of the media and the association with the government is very strong yet. So imagine putting the internet under that model, right, of regulation. So I think that's a problem. And the other one is not really paying attention to the aspect of concentration, because all of this is enabled because there's only like 1, 2, or maybe 3 big players when it comes to telecoms and to media in each one of the Latin American countries that you can name as a general rule, right? So I know that some people would say that a more federated or not concentrated social media landscape won't be necessarily better in some cases, but most of the issues that we are dealing with in terms of compounded harms, if you may, let me use that strange term, wouldn't be an issue with a more decentralized space. I'm not talking about something that doesn't even speak to each other or where virality is impossible, but there are models to explore. And I don't think that legislation that is very targeted to the bigger platforms is having that in mind. Let's see how this interplays with DMA or with some other developments. Maybe that's the thing that is needed for the vision to be complete.
Can I just second something that Javi just said? I think
Please.
The connection with competition is really underappreciated sometimes, and the Texas and Florida laws illustrate this. The reasoning of these lawmakers was, oh, platforms are so big, they have so much power over speech, we are going to have to tell them how to use it. Like, our hands are tied. We're going to have to take this power for ourselves and use the state to say what speech should be like on the internet, as if there were no such thing as a remedy that sounds in competition instead, and that is about reducing the power instead of moving the power into the hands of the state. And it plays out in, the First Amendment analysis of whether they can do it. The fact, if there's bottleneck control, they're more able to do it. But to Javi's point, approaches that ask about the bottleneck control before handing it off to the government seem like the right first step.
And so, and Daphne, I was going to go to you also because you were going to ask a question of Chinmay, and I want to let you do that, and then we can come back to this question, because there clearly are, or there is a range of regulatory options to deal with some of the problems that we're all identifying. That's come up in most of the comments on this panel, and I want to certainly in our last few minutes be able to get to that. But I want to let you ask the question that you were signaling you wanted to ask related to jurisdiction that Chinmay had raised.
This is so nerdy, but I think we have a lot of lawyers. So we're going to have this moment in the spring when DSA compliance is due in like a month. Platforms are trying to do their DSA compliance in the middle of layoffs and the Elon Musk debacle. And then the Supreme Court's going to change everything right at that moment, and it's going to be crazy. But one of the results might well be that for the first time we see jurisdictional conflict where one country is saying you have to leave this up and the other is saying you have to take it down. And so far, every case I've seen, and I watch them pretty carefully, has been one country saying you have to take this down and another country saying you can take it down, you don't have to, it's up to you. And the court, in considering a global takedown order in that situation, applying comity analysis, does what the Supreme Court of Canada does, which is to say there's no hard conflict, there's no obligation to carry this somewhere else, and so it's okay for me to issue a global order that won't tread on the sovereignty of other countries. Once we start having a conflict of must carry obligations and removal obligations, that changes. And so my question, it's very speculative, is will that change courts' willingness to issue global orders? Will the courts become more bought into jurisdictionally limited orders as a result of that? And is that a good thing? And Chinmay, it's not fair to tag you with this question, but I think it is a big one now.
I have two words for you, Daphne. Yahoo Lycra. Sorry for all the non-nerds over here. I thank you. Yeah, that's a great illustration of the question. I feel like they'll use geo-blocking because they're just going to end up doing in different states what different states want. But that's interesting because that takes us further away from the idea of common values, right? Because then it's each state is sort of its own particular mess or not, depending on how it's constructed itself. But wait, did I interrupt you? Have you finished saying? Okay. To me, that sounds like a sketchy future for states that lean towards authoritarian ideas about speech, because that means that they're no longer, their regulations are no longer being held up to a global standard. This is a world in which we're saying each state just defines its speech environment, and instinctively I don't like it. But I've decided to be optimistic for 30 seconds. And I'm going to say that the great thing about these cases is I feel like as an academic, they raise such fascinating questions. I mean, the downside, of course, is that there's not a lot of time to get our heads around those questions, and we're going to have an answer whether we like it or not from people who are not going to wait till the fall issue of the papers that all of us want to write about it. But each one, I think, raises an interesting question. The ones about transparency and opening up platform decision-making is one that I would love to explore in more detail. Since I'm on a different course from you, Daphne, I will say cautiously that while I don't agree with these particular must-carry rules, it's interesting to me as a question of should states lightly regulate the degree to which platforms make choices about what kind of electoral content they host. And then I think ranking again, as I said before, is is a question that we should be asking. I just don't like the knee-jerk answers that we're coming out with. And so I feel like Faria summarizes it well when she says that there's a fine balance to be struck. But I will add to that by saying that, unfortunately, what we seem to be seeing is a state platform alliance in the striking of this balance of states. When states say that we will come and tell you what to do, then we're basically having the entity that all speech laws have been directed at keeping far away from the regulation of speech is offering to step in. And that is certainly not an ideal solution, which leaves us with the very easy questions of what kind of regulator would we want? What would their allegiance be to? Which constitution? Is it international human rights? What are the values? How do they carry out their duties in a legitimate manner so that the people who they are supposed to serve feel like they're actually being served? And I don't have the answer to the questions, but circling back to what David said earlier, there have been so many models like the social media councils, et cetera, that have come up in the past. And I think that it's a shame that we haven't had the time to, and I don't mean us as a panel, I mean us as a people, to explore those fully. I'll stop here.
No, that was really great. I want to make sure that we get at least to one of the questions that was posed by, it may be 3 anonymous attendees, it could be 1 anonymous attendee, but we could take any of these questions. They're all actually really quite good. But we've been talking about this from the perspective of sort of from the regulatory side, right? What are governments going to do, and what might the impact be? But the first question that is asked has to do with like looking at this from the company perspective, and maybe we could just imagine for a moment. I want to get to this question of just what you think of this question of, is it possible for the companies to keep up with differing requirements globally, especially for smaller companies? I mean, I think the easy answer for smaller companies is probably it's going to be hard for smaller companies. They're not going to have the resources to do this kind of work. And it's going to, as I think many of us have argued for years, it's going to have an impact on innovation and competition and so forth. But is there something that you would advise companies to be doing, I suppose particularly the biggest ones, in the face of a kind of explosion of regulatory mandates that we might see around the world? How do companies respond to that? Sort of open that up to anybody who might want to give a response on what's the company response to all this. Anybody want to jump on that? Javier, what would you I'm sorry to pick on you, but you're in contact and conversation with companies pretty regularly. What's your take on how they respond to this kind of differing regulatory requirements around the world?
So the general, I would initially subscribe to the basic civil society claim, which is comply with the legislation that is aimed at extending the rights of users and enhancing free expression, and be careful and comply with that, but don't comply with the regulations that are intended to curb expression and come from authoritarian governments. The problem is that companies will always want to make money, right? And they will just privilege what they want to do. Turkey is an example, right? Remember I don't know if you remember this, but there's a lot of civil society organizations who are really like pushing for companies to push back against these regulations and the hostage laws, right? And all of that. But in the end, they end up giving in. Vietnam is another example. So I don't remember many cases in which the companies really stood their ground and said, I'd rather not give service in this country, or not set up a cloud service in your Google Cloud in Saudi Arabia, or I'd rather not work here and not make money and stick to my principles. I haven't seen that, or I don't remember. Sorry, maybe the examples are too many on the other side of things. So I think that the effort to try to make them be principled and pick the fights is complicated. So what I would say to them is, try to do your best in this sense. I know that you won't. And again, I would just insist with this other aspect. Only having many companies that have more approaches to this, or more models about this can give us a hint of what can be possible. But at this scale, the choice is like is pretty much a binary choice. And in this case of companies, it's only money. And that's how it's going to be. At least until they diminish in size, like Facebook is happening now.
Right. Thanks. That's great. So we're really at the very end of our time, but I want to give our panelists just a second to have a last word. And Faria, I saw your hand.
Just to Javier's point about companies, and of course they're going to do it, but what I saw, and at least with the social media rules in Pakistan, as the Asia Internet Coalition, when the companies banded together in a unified voice saying, we've forced to not provide our services, that's something that works, which we haven't seen very often. But what is also going to happen is you're going to see what the same companies are doing in different regions, and they're complying or not complying for different reasons, right? Again, whether they're incorporated, they have staff, there's a different liability or risk assessment. So they may do one thing in one jurisdiction, but another, but it's going to have narrative, persuasive value. So for example, what's happening in the US Supreme Court, whatever the decision, there's going to be this narrative, persuasive thing where if it's happening there, if their Supreme Court did whatever, why should we take a different direction? So it's always going to be used or exploited one way or the other. We've seen that regulators, the executive, or even in the legislature, this tends to come up where examples are cited to restrict a little more, to do it differently. And that's why I think globally it's important. Our eyes are also on the Supreme Court, even if it's not directly applicable in our jurisdiction.
Great, thank you. A last word, Daphne?
I will offer a metaphor for what's about to happen in the US. If you've ever played a card game where you have the option to just trade in your hand for a different hand, I think that's the position US internet lawyers are in. So everybody hold on to your hats.
Great. And Chinmay?
Sorry, I was laughing because Daphne said my optimism wasn't optimistic enough. So I'm going to go with what Daphne says. And like I said, as an academic, I'm very excited about these questions and about the shaking up of things. But I think more seriously, I am concerned about the outcome. And unfortunately, and here I will not even pretend that I'm being optimistic. I think that Faria is exactly right and as is Javier, in their instincts that platforms are about negotiations with power in the end. And so I think it just really comes down to which market do they want to be in, what are their incentives to be in that market versus will leaving a market have minimal costs, but give them brownie points in another market. And I'm sorry if this is very jaded, but they are companies with particular goals, and I think it's important not to lose sight of that. I hope that the Supreme Court will keep that in mind when it makes its decisions.
Great, thank you for that. And really thanks to all of you. This was an amazing discussion. Especially want to thank you for going almost an hour without mentioning Elon Musk. That was also impressive. So we had a little bit of Musk-free zone there. But I really want to thank you all for highlighting just the extent to which this is an area of extreme ferment, really. I mean, we don't know. And this is obviously hard, certainly hard if you're a lawyer in practice and you need to advise a client. We don't know where we're going to be in 6 to 9 months. And I think that's a hard place to be, but the issues are pretty clear. And I want to thank this panel for highlighting not only the importance of these issues in a US context, but also how they play off and relate to issues around the world, and also how those issues are frankly differently thought through in different parts of the world. And that's a conversation that unfortunately we don't get very often in US debate. Thankfully, we have organizations like CDT that make sure we do have forums for that. And so I'll conclude by again thanking CDT and thanking all of our participants for joining us today. This has been a rare forum where the participant number has gone up as the panel went along, and I was happy to see that. So thank you very much. Thanks to everybody for joining. I don't know if I turned it back over to Emma or simply say goodbye. Hi, Emma.
Yes, hi. Thank you all so much. David, Mai, Daphne, Faria, Javier, that was an excellent conversation. I wish we had several more hours to keep going. But we are going to take a short break now to get the panelists for our next and final panel on and to give our closed captioner a little bit of a rest. So we are going to start back here at about 1:38 p.m. Eastern time. But thank you all so much. Really appreciate it.
Thanks, everybody. See you. Bye.
Hello, everyone. Welcome back. For our final panel for this year's Future of Speech Online event, we're going to move our focus beyond the social media services that take up so much of the conversation space around online content regulation and consider the debates about content interventions that are occurring by intermediaries elsewhere in the stack. I'm joined for this final panel by an amazing set of panelists, including Yosef Getachew, the Media and Democracy Program Director at Common Cause, Corinne McSherry, the legal director at the Electronic Frontier Foundation, Blake Reed, who's a clinical professor at Colorado Law, where he also serves as the director of the Samuelson Glushko Technology Clinic at the Silicon Flatirons, and Dmitry Vitaliev, the founder and director of Equality, a technology company that creates accessible technology with the goal of promoting and defending human rights on the internet. So we have just about 50 minutes for this conversation. Apologies that we're running a little bit late, but I know there's a lot we want to dig into, so I'll just dive in. First question for Yosef. So the Florida and Texas social media laws that we've been talking about throughout this event are sometimes described as enforcing common carriage on social media services. They have provisions that would prevent social media from taking down content that was not otherwise illegal, and in some cases even saying it's illegal to deplatform a politician or a candidate for office. Common Cause has done a lot of work on fighting election disinformation online. So I'm curious, can you tell us what has that work entailed and what kind of implications would a common carriage kind of rule for social media services have for that work?
Sure, and thanks to Emma and CDT for inviting me to be on this panel. I'm really excited to be here with some great panelists. So as Emma mentioned, my name is Yosef Getachew. I'm the Media and Democracy Program Director at Common Cause. For those who are unaware, Common Cause is a democracy reform organization. We work to ensure our values of democracy are infused throughout public policy. When it comes to social media, for the last several years, we've run a social media monitoring effort where we have trained thousands of volunteers to actually monitor the major social media platforms for the spread of election disinformation. This is content that is designed to deprive an individual of their right to vote or otherwise disrupt the progress of our democracy. And just to give you some background of the way this program works and kind of the practicalities of content moderation, we have really just triaged much of the tips and content our volunteers have flagged into what we believe are the most actionable items where the content is violative of platform policies. Then we actually share this content with the platforms and submit takedown requests. In general, more times than not, platforms are not going to actually take action on the content that we flag. They're in the business of keeping content up. And we have several back and forth with them about why we think certain content is in violation. The reality is that platforms don't necessarily like taking content down. That being said, there are certain situations where there are clear-cut cases where content is violative. For example, if an individual is saying that Democrats vote Wednesday and a platform has a policy that says that content that is false about the time, place, and manner on how to vote is not allowed. That's more of a clear-cut case. But the policies themselves aren't necessarily the most robust. In connection with takedown requests, we've led a year-long campaign, and even going back to 2020, we've led a multi-year campaign getting platforms to actually strengthen their policies around civic integrity. Part of the challenge is that there are holes in many of these policies that bad actors are exploiting to spread disinformation, whether that's newsworthiness exemptions or algorithmic amplification or other business practices that have incentivized the spread. It's really on the platforms themselves. So what does this mean when it comes to common carriage? And I know Blake will talk a bit about this, so maybe to give a preview for some of his comments. The way I look at common carriage is that it has its roots in economic policy. It's this idea that a good or a service is so essential that in order to carry it, you need to ensure that it can transfer from one market to another. That has really just evolved into if we think something is so essential that a provider of that good or service needs to treat all customers the same and not discriminate against them is really how it's evolved over time. I think the challenge is when it comes to speech, when it comes to content moderation, I don't think that common carriage is a perfect fit for what we're talking about in terms of regulating content. I mentioned that common carriage has its economic roots. I think speech itself is not a purely economic issue. There are issues when it comes to public safety and speech that we've seen in the January 6th insurrection as an example. There are issues about free expression and making sure that a variety of communities can actually share their opinions throughout the internet ecosystem. And even from an economic standpoint, there are ways where some speech is amplified over others. And I think there are economic issues there where I'm not sure if common carriage is a perfect fit. So really what we've been advocating for is just kind of alternative methods of regulation that look at business models that incentivize harmful content rather than actual common carriage regulation, simply because if we're going to operate in a way where we think that all speech is deemed critical, you run the risk of platforms leaving up harmful speech, speech that would otherwise be violative of policies or disrupt our democracy in the broader sense.
Yeah, thank you, Yosef. It's, I think, always good to kind of underscore and remind folks that the way that most online services do content moderation, they are taking down a lot more speech than could ever be restricted directly by by the state under laws, and that's actually oftentimes what their users are expecting or looking for, or a kind of a key tool in keeping online communication spaces functional or focused or on topic. I'd like to, now go to Blake to dig a little bit more into what we actually mean by common carriage in US law. So Blake, can you tell us your perspective? Is common carriage a useful concept for thinking about social media services or any other technical intermediary? And what kinds of infrastructure providers are we thinking about, or are we talking about when we're looking at content interventions beyond social media?
Thanks, Emma. I really appreciate the opportunity to be here. And just by way of disclaimer, I should say I'm here on my personal academic capacity and not that of any of my affiliations or clients or anything like that. So when I think about common carriage law broadly construed, I think we're sort of wrapping up really three distinct questions. One, what are common carriers? So like what firms count as common carriers? Two, when we talk about common carriage rules, what do we mean by common carriage rules as a requirement or maybe behavior by firms? And then third, if we're going to impose rules on common carriage rules on common carriers, what does that mean for the First Amendment? In the first bucket, Harold Feld teed this up in yesterday's conversation a little bit. And Yosef alluded to as well. We've got this long, history of regulation. Some of it has sort of economic roots. Does a firm possess market power? Some of it is essentiality. Is this so important? Members of the public have to deal with this entity in such a way that they're affected with the public interest. There's some other characteristics that we have thrown out, but I think in at least in U.S. law in the past, call it the post-Civil War tradition, U.S. law, we've largely identified common carriers by statutory regimes. So the Interstate Commerce Act and its amendments, the Communications Act and its amendments, lately, these Texas and Florida social media laws are another good example of this, where the common thread is pretty much, have you attracted enough attention from the legislature to warrant regulatory intervention? Does the legislature want to call you a common carrier? And maybe in the scope of the Communications Act, does the FCC want to call you a common carrier? And that's sort of the keystone. So I don't know that we have like a really coherent, and consistent basis for declaring who is a common carrier, who gets hit with these regimes. We have some indicia, right? As Yosef was getting at, market power, really important, control over speech, gatekeeper power. But even those are not really satisfactory definitions, because we have lots of monopolists and lots of communications gatekeepers to which we do not apply common carriage regulations and to which we might not want to. And I don't think we've done the hard work of mapping out the infrastructure space, which I kind of think of as the entities that sit between your internet service provider that you interact with and the applications that you interact with, your email provider, your search engine provider, Netflix and YouTube, and, everything, social media platforms, everything else you interact online. So we're talking about, DNS providers and registrars. We're talking about security services, caching and content delivery networks, web hosts, payment services. There's a whole ecosystem of payment providers, membership management services, ad tech services, blogging platforms. We'll probably talk about app stores. We can talk about browsers. And so I think, what is the case to call all of those common carriers? I don't think we've really even started to do much of that analysis, and we could have long arguments about those. I'll also just say quickly that if we shift to thinking about what are common carrier rules, there's this overarching notion of we want you to serve everyone, but it's never really everyone, right? It's more that we have a loose, constellation of rules that bar and permit certain kinds of discrimination. So even going back to some of the historical examples, like there's huge disagreement in the body of telegraph law about telegraph carriers handling illegal content. And are you obliged to carry illegal content? Are you not? So even within particular regimes, we don't have really consistent rules. And then we see wide variations across regimes, right? So some folks will consider doctrines like the fairness doctrine for broadcast TV to be part of the common carriage or quasi-common carriage sort of canon. And that looks radically different, right? It's like sort of a multi-stakeholder agreement between the broadcast industry and the FCC for how to govern the content of what goes on broadcast TV. And that looks really different from, you know, the common carriage obligations we'd apply to a telephone company or net neutrality. So again, like what those rules might look like in the context of particular infrastructural providers, we don't have a real clear answer. We have lots of historical examples to draw from. And then the last thing to say is whether we can permissibly impose those by regulation, or, you know, if we decide to go beyond industry standards and practices, whether that's permissible under the First Amendment. We also don't have really good answers for that, right? And I think the fight that's happening at the Supreme Court right now over the Texas and Florida social media laws will shed some light on that, but not all, right? Just like the fight over the First Amendment in the net neutrality context gives us some clues, but doesn't really cover the waterfront. So I think this is really kind of untread territory, or we're trotting it today. And I don't think we have clear answers from the history, which is kind of what makes it exciting to talk about. So I'll stop there.
Thank you so much, Blake. And I do want to come back to some more of that forecasting of what might these Supreme Court decisions actually mean for some of these questions for other kinds of intermediaries. But I also now want to welcome Dimitri from Equality to the panel, and to actually bring in the perspective of somebody who runs a service that you could call a kind of intermediary service or sort of an infrastructure service. So Dimitri, Equality provides a few different types of intermediary services to civil society organizations around the world, but you very much don't operate as a common carrier in that kind of language. You expect those organizations to meet certain standards around content, and you actually push them on it and kind of hold them to those standards. So could you describe for us the deflect service that Equality provides and what kinds of values you're promoting with that? How do you put those values into practice as a kind of technical matter?
Sure, and good evening, everyone, from my hotel room in Istanbul. That's right. So Equality develops technology and provides services in defense of human rights online. The platform you mentioned, Deflect, protects websites from various forms of cyber attack. We also have another project where we're actually grappling with how to implement content carriage rules or content moderation rules on a network that is meant to help people avoid censorship on the internet. But maybe I'll leave that for later or for question times if anyone's interested. So just to give a little bit of context, Deflect is, you know, like a smaller Cloudflare. We offer caching, defenses from cyber attack, analytics. It is a transnational service with clients from about 80 countries, about 20 million unique IPs accessing our network every month. Right from the beginning, we decided to accept responsibility for the content carried on our networks and defined our service provision around certain principles. Now, we've tried to improve them and iterate them over 10 years of trial and error. But now we feel that at least on our network, we have it right. And we think that this model can scale and be applicable to most content carriers today. Like you mentioned, I think this is an important addendum, is that quite a large majority of our clientele are media and activist organizations from around the world that you might agree is not a crowd which is easily muzzled. And is definitely on the end of quite a lot of technical, legal, and social engineering attacks. So what are these principles, or what kind of forms our content moderation approach? Well, first of all, a clear terms of service that is served to the user right up front during sign-up. It is written in simple language, it is concise. The part about content restrictions is summarized in 2 paragraphs, and obviously it is translated into multiple languages since we have an international audience. Content restrictions include prohibition of hate speech, incitement to violence, spreading malware, and the like. I guess most in the audience might ask, well, who decides what is hateful content? Well, on our networks, we do. We are the operators and the owners of the service. We don't always do this by ourselves. We seek out local expertise from a global network of contacts, also media, human rights organizations, and various lawyers, but for helping us understand the issue that is being debated at the moment, not for delegating our responsibility to them. And in the end, if answers, cannot easily be found, well, we lean on Canadian law. We're a Montreal-based registered organization. And also we lean on the International Bill of Human Rights for definitions and interpretations. I think we accept that most of the issues around content moderation are not new, have already been thoroughly thought about and decided upon by many smart people who came before us. Another important distinction, I think, is equal application of these rules. We have to accept that our policies may often mean that we're acting against our personal beliefs in some cases. More often than we like, we end up protecting the privacy of people who we may vehemently disagree with when their rights have been violated by our clients. These are not algorithms making these decisions, it's the humans making these decisions. And I think this is an important distinction. We give clear timelines for the case resolution up front. We give enough warning for clients to respond in time. In 10 years of running the service, working with thousands of clients, this process has resulted in a single use case of one client being offboarded for refusing to take down content in violation of the terms of service. Having said that, also, we are cognizant that about 3/4 of the abuse complaints and takedown requests that we get are erroneous. Most of the time, people don't like what this media or what these human rights organizations are publishing. Or quite often, these are simply social engineering attacks trying to force our clients offline. So we think this model can scale in a very, I guess, maybe simplistic, algorithmic way. At the moment, we have around 1,000 clients. It takes us on average 2% of one person's monthly schedule to deal with all of the abuse complaints. Now, should we scale this organization to 50,000 clients, it would be a full-time role in the team. To 1 million clients, it would be a team of 20. This should be affordable for a company with 1 million clients. I think in the end, motivation is key. The way you define the company's principles helps you also define the investment that you need to make to stick to them, and helps you ensure staff buy-in and dedication. Yeah, happy to go into more details later on about the specifics of our clientele and the use cases that we've been through with them, or to talk to you more about how to apply these rules in a project that is meant to route around censorship. Just ask me.
That's great. Thank you so much, Dmitry. It's really helpful to get that kind of very specific view from trying to apply these sorts of rules at scale and the kinds of considerations that you've had to take on board, and especially the estimates of how much work it actually is, and how many of those takedown requests are actually fraudulent or intended to silence your clients. But I want to, before we dig more into that and everything else that folks have raised, I want to bring in Corinne. So Corinne, EFF has just launched a Protect the Stack statement signed by more than 50 civil society groups from around the world, highlighting the risks of content interventions by intermediaries beyond the application layer, kind of throughout the stack. What are some of these risks, and why did interventions, including things like what Dmitry was just describing, raise such concerns?
Sure. And I would say, first of all, so thanks. And it's fun to be here with this group of people and talk about this thing that I've been spending way too much time thinking about over the last year. Maybe not too much time. It's a huge problem. So the reason why we and many other people worry about content interventions sort of beyond platforms is actually, first and foremost, I would say, because very few companies or organizations that are engaging in those interventions are doing so with anything like the care that Dmitry was just describing. And not only that whether they want to or not, in many cases, they're not, depending on the kind of service we're talking about, they may not be positioned to do that kind of, or to take that kind of care. So it sort of depends on what kind of service you're talking about. As Blake was mentioning and other people were mentioning, there are many different kinds of services that make up the stack, but all of them are sort of links between, you know, speaker and audience in different kinds of ways. And depending on where they sit in the stack, the sort of risks to human rights of them intervening will vary. So, but I'll just give some examples. In many instances, we know that platforms don't do a particularly great job of moderating with precision. We know that that is true because it's a really, really hard job. But beyond platforms, for many infrastructure level services, they actually can't really moderate with precision. They can only take down an entire website, for example, because as opposed to identifying, you know, particular language, particular sort of subpages where there's a problem, their only relationship is to the entire site, and so the whole site gets taken down. Or, you know, at the ISP level, to go way down the stack, you know, they can only cut off an account, even though it may be that there's multiple people using that account and only one of them is doing something that is hateful. So overblocking is almost inevitable in most cases. On the other side of that is that due process is going to be hard. So when that overblocking happens, when the mistakes are made, as inevitably they are, we know this from looking at the platform level, the speaker who's trying to reach an audience, or the audience who maybe wants access to that information, may not have a relationship with the service provider that's actually interfering or intervening. So there isn't a way to appeal, there isn't a way to challenge it. And related to that, in the case of the audiences, they may not even know what they don't know. So if a website gets taken down, let's say someone sends you a link and say, hey, check this out. And then you click on that link and it's, you know, it's no longer available. You may not know why. Even you don't know what was there, and you don't know why it was taken down necessarily. You don't know if maybe the original person who put up the site took it down themselves. Was it taken down by a government? Who knows? There's a lot of unknowns there. And then of course there's all the links to sites that you never see because they don't exist anymore at all. Another problem is that it gets back to competition, which came up in the previous panel. And I agree with what was said there, which is competition is really not discussed nearly enough in the context of these conversations. So depending on what layer of the stack you're at, you know, someone may be able to switch providers, or they may not. They may not be in a position where actually they have any alternatives. And either because those alternatives don't exist, or maybe they're not technically savvy enough to be able to move, you know, to move to another site, to reconstitute their site somewhere else where maybe they're less vulnerable to state sanctions or something like that, or the provider is less vulnerable to pressure. So switching can be really hard when you're going up and down the stack. And relatedly, I would call out the situation of payment processors. Now, there's a fair number of payment processors, but there's some of them that are huge. So if Visa and MasterCard decide they're not processing payments to you anymore, as started, you know, way back when with WikiLeaks, back when we liked WikiLeaks a little more, you know, Visa and MasterCard decided to cut WikiLeaks off, and that was a real problem, right? But imagine you're a tiny nonprofit and you're expecting your money. It's the end of the year. All of a sudden, you know, your usual payment processor has been pressured by a government or some other private party to stop processing payments to you. Well, that's a real problem. That could be sort of absolutely mission critical. You know, sort of, I think related to that, I do think that every time service providers intervene, it creates a pathway for further intervention. And so what can happen is maybe a service provider intervenes and we all agree, like, that person's terrible. That should completely happen. They should not be on the internet. Well, chances are that pathway, now that it's created, now that service provider has signaled that it will do that, it's going to get pressured from others, and it's going to, and that pathway will be deployed against all kinds of other services and other groups. And most likely, those are going to be the most marginalized groups, the people who are least able to push back. I mean, it's sort of the problem with infrastructure in a nutshell is that all of the problems that we have seen with respect to platform level content interventions apply elsewhere in the stack and are worse elsewhere in the stack and more difficult elsewhere in the stack. And so that's kind of what it comes down to it. And the last thing that I would say is that the reason that protect the stack, one of the things I'm very happy about with the protect the stack statement is that, which I can put in the chat, or maybe the host can put it in the chat, is that so many groups around the world signed on to it. And the reason I want to highlight that is that I think that these kinds of interventions look very different depending on where you sit in the world. And there are lots of people in sort of majority world who experience these kind of interventions all the time in much more drastic ways, and worry about them, and are also very usually not well positioned to push back, or even worse, less well positioned than groups in sort of the global north, where often the companies that they're dealing with are actually located. So I think that's why we saw so many groups from outside the US and outside the EU joining the statement, because they really experience it every day. And I will stop there. Thanks.
Thank you so much, Corinne. So much to dig into from what you were laying out and what's in the Protect the Stack statement as well. Talking about financial intermediaries made me think of many years of seeing payment processors, including in the US, really taking a hard line against a lot of material having to do with sex and sexuality, whether it's people publishing erotica or people trying to process payments on a site like OnlyFans. And that, especially in the wake of SESTA FOSTA here in the US, we've seen such a crackdown by different intermediaries on people in the sex worker community, and people who are not the target of the law by any means, but the kind of pressure on different intermediaries, both content hosts, but also payment processors and a lot of other services, to kind of make people engaged in sex work or advocating for its legalization or advocating for health and safety, really increasingly pushed to the margins. So it's, these are not hypothetical concerns that you're raising at all. I wanted to open it up to everyone for some thoughts, because there's been some high profile conversations going on around moderation by different kinds of infrastructure providers just in this past week, where app stores have been in the headlines again. And Elon Musk has been picking a very public fight with Tim Cook over the Apple App Store's rules. I think we were just hearing earlier today from Senator Blackburn about a bill that she's co-sponsoring in Congress that's designed to keep Apple from being able to exercise some of these content moderation and content policy rules that it has in its app stores. So question for all the panelists, what roles do you think an app store should play in making decisions about what apps are available? When should they intervene? When shouldn't they intervene? Should we think of them as this kind of infrastructure? Yes, Blake.
I will jump in on that one, just to say, so I think a threshold thing I would start with app stores is we should think about app stores, and frankly I think we should think about all the different silos of infrastructure as potentially being different sites for developing policy with different affordances, with different implications, different considerations, and I think app stores are a terrific example of that, because let's take the competitive dynamics are kind of complex and interesting in app stores, right? So if we from a particular view, Apple has a tremendous degree of control over what sort of software people can install on what might be their main computing devices, and that's particularly true here in the United States. On the other hand, if you look sort of worldwide, Apple is nowhere close to the dominant provider of services. And are they that important of a choke point worldwide? App stores are also really proximate to operating systems, right? Which means that the decisions Apple has made, for example, about how it architects its system for security and privacy and usability and accessibility are kind of neatly intertwined, are maybe messily intertwined with the with the decisions that it makes on the App Store. So we have to think really carefully about what the sort of policy intervention for the App Store that makes sense. And that might look really different than the policy intervention that we come up with for search or for e-commerce or for web hosting or for payment processors or DNS and security services and so on and so forth. I was thinking about Jonathan Zatrain's concept of generative computers generativity. And, the iPhone is a good example of what Zatrain calls kind of a red device. It's locked down. You can't do that much with it that the platform provider doesn't let you. And there are real downsides to that if that's the only computer people have access to, right? Suddenly, the ability to compute broadly is really implicated by exercising that control. On the other hand, there are a great number of users of iPhones who really benefit. In fact, it's probably a usability and security and privacy upside that it is so locked down that there's, that you go through a lot of friction to add software to your phone, that there's not ways to install arbitrary code. And so thinking about, sort of a straight common carriage obligation on the App Store, that's pretty scary to me, right? If I think about, oh no, my mom's going to get prompted by, rogue websites that she's visiting to install software that's going to replace her TCP IP stack and surveil everything that she's doing. That's a pretty bad result, right? On the other hand, what about an iPhone being used in a repressive country and somebody wants to be able to install a secure communications method that maybe circumvents nation state level surveillance, and then they have to deal with Apple's relationship with the local authorities to get around that. Hard questions, right? So I think I just highlight those examples to say we should really beware of saying non-discrimination regime, no censorship, sideloading across the board, everywhere in the world for every phone, for every user. Like that seems clearly to me to be the wrong approach. I think there's also a strong argument that Apple deciding what software everybody gets to use on their primary computing device is problematic. And the question is, where do you draw those rules in the middle? And I'm avoiding saying Elon Musk because I hate the notion that this is the sort of catalyst or the crucible, this current kind of fight that we're having over Twitter to resolve these questions. I don't think it's a particularly helpful set of facts to resolve them.
So I'm reminded of the adage of bad facts make bad law or bad policy. Yeah. Corinne, I see you have your hand up.
Yeah, so I just want to, first of all, plus one, Blake's sort of initial comment, which is that we really have to be careful in terms of how we're thinking about policy and especially regulation, but even in terms of what we're promoting and proposing as a voluntary matter, you really do want to look at what kind of service you're talking about. And it matters, the context matters. And that's too bad because it makes it harder and more complicated, but it also is the reality of the situation. And the other thing is that I agree with Blake that I don't think we want a sort of, across the board regulation that says all app stores must do X, right? Or a common carriage thing. First of all, in the United States, I think that's just unconstitutional aside from everything else. But I think we might do, though, is think about how can we get some rules out of the way. We have laws on the books that actually help Apple lock down its power. And I wish that there was more attention paid to that. And the reason I raise it is because my organization has been complaining about the Apple App Store as long as there's been an Apple App Store. I'm pretty sure, because the developer agreement is terrible, but also because of the way it locks people down. But also, there is a law under US copyright or para-copyright laws called Section 1201 that Apple tried to use to make it actually illegal to help people jailbreak or sideload so that they could load apps that weren't approved by Apple. So EFF goes every 3 years to the Copyright Office to get permission for folks to do that. It's complicated. I won't belabor the point, but and Apple doesn't really even fight us anymore because they've realized it doesn't hurt their business model particularly. But that's an example of the kind of law that's on the books, that's in place, that's helping Apple maintain its power. So maybe we could start by getting rid of some laws that inhibit competition and see where we are at that point. And I'm sure that that's true with respect to other services up and down the stack.
Yeah, just to jump in and chime in here, I generally agree with both Blake and Corinne. A couple of things I'm thinking about is as we get into more and more layers of the stack, it gets very complicated in terms of what the right policy framework should be, as Blake mentioned. And with app stores, they're in such a unique place because they can determine what apps get placed and which ones don't. And there is a competition issue as well. But also from a corporate accountability standpoint, I think we should also be asking what are the responsibilities of different providers in the stack, in particular app stores, of making sure that the apps that they are allowing follow a certain baseline criteria. And what I'm thinking about more specifically is around democracy issues. Like, democracy and technology is so intertwined that folks participate in our democracy through access to technology, access to apps. Apple App Store, Google Play Store, they have rules on the books when it comes to prohibiting criminal activity, prohibiting harassment, but there are no rules around just democracy issues. There are no rules around civic integrity. And I don't know if this would be applicable to all layers, but I certainly think at the App Store level, there should be some baseline civic integrity policy. The challenge here is that there are apps currently on the App Store that we believe would undermine democratic participation. There's an app on the App Store, on Apple App Store, Google Play Store now, that encourages voters to quote unquote report illegal activity at the ballot box. This is really in correlation to narratives around election denialism and voter fraud that have been percolating way back to 2020 and even now. And our struggle has been when we flag apps like this, we're trying to connect the dots between certain policies on the books, whether it's prohibiting criminal activity, harassment, and there's no neat fit for that. There are other apps and even podcasts right now on Apple Podcasts that are promoting election denialism, promoting hateful content. And when we're talking about takedowns or not allowing certain things to run, I think before we even get there, we should decide what are the rules on the books when it comes to certain content around this nature that we're just not seeing right now. So it's starting from what are the rules from a corporate accountability standpoint, and then applying those rules consistently.
Thank you. I want to remind our audience that you can still submit questions. We will turn to those in just a minute, either through the Q&A function or to questions@cdt.org. But I also wanted to come to Dmitry. I see you're off mic, so you have a comment there. I was hoping whatever you were planning to say, and then also I know that one of the things that Equality, also another service that you provide, is a service called censorship.no that is all about circumventing restrictions that other people, including other intermediaries, might put in place on people's access to information. So I'd love also to get your thoughts on how you see drawing that line or balancing those different tensions between the kinds of approaches you take with the Deflect service and with censorship.no.
Cool, thank you. Yeah, I was going to say something, but I don't think I would have added anything particularly great to already the good things that have been said. Maybe just one small thing with regards to global content moderation, performed by these, giant monopolies that, form a big part of the content carriage and content creation on the internet today. I think the last 20 years have shown that it is kind of impossible for them to have their cake and eat it too, to have enforceable content moderation policies that protect its users, whilst at the same time, to please various governments around the world that have different takes on what content moderation should look like. These models obviously do not work, cannot be perfected by machines. Why do we persist at it? Maybe it's all right that, these companies are decentralized, their responsibility is decentralized. Maybe it's all right that, global content moderation isn't necessarily led by US policies and US moralities. Maybe it's not such a bad thing. Having said that, I'll probably try to argue with myself now. So yeah, we run a service. Well, it's actually, we create software that by virtue of installing it on your device, you are part of a network of users all around the world. And together in this network, you are helping each other access various types of content. In practice, you are able to circumvent all forms of internet censorship as are technically practiced today. Hence, the project is called Censorship No. But yeah, in the beginning, as you may recall, I gave a whole speech about how we're a principal company, there to defend not only freedom of expression, but all human rights on the internet. Freedom of expression, exists in parallel to other very important and inalienable rights as well. So on this network, we may not necessarily want to support the ability for people to retrieve any type of content. But how do we moderate, in other words, censor on a network that is named Censorship No? What we're coming to, thinking about this for several years now, and trying out different things on the network itself, is that it doesn't have to be about content. You can create other policies, protocol level implementations and changes that help, for example, content expire. One of the things that our network does is caches content in people's phones and allows them to share it with each other. We're actually using the BitTorrent protocol to make it happen. So therefore, not everybody has to go around the censorship, but only the first user, and thereafter they're sharing content from the phone with everybody else. Now, this content, by and large, doesn't need to exist in perpetuity. It could be good content, it could be malicious content. We don't know, we don't see this content. But what we can do is create a protocol level decision that all content expires after 24 hours and has to be resought from the origin source in the beginning. We can also state clearly and simply, what this software is actually for and what we don't want it used for. Now, it's a simple gesture, but in our experience, it does discourage a small amount of users that would want to use it maliciously or would want to use it for purposes not intended by the creator of the software. They may have second thoughts, like, if this company doesn't support what I want to do here, maybe they've built something into this tool as well that would stop me from doing it or that would expose me from doing it. Maybe it's obvious, maybe not, but I think it is also very important to keep this kind of code and these kind of policies transparent, printed upfront, and clear. So we're still grappling on, how can we stop malicious content on our network? But we're realizing that there are other methods we can take, that we don't need to be 100% successful, but we should be successful most of the time in doing this. And that lightens the burden on ourselves as well. And we also try and inform the user and engage in this type of debates to show that not only, are we willing to give it talking time, but we're also looking at it from a protocol and a governance perspective.
Thank you so much. And I'd love to invite other panelists to respond to any of what you've heard each other discuss so far on the panel, but I did also want to bring at least one of the audience questions before you all, which is a fairly simple question, but probably a pretty deep answer, asking the panelists to talk about lessons that we may have learned under US law from the Digital Millennium Copyright Act, the DMCA, and its notice and takedown policies in this space. What lessons have we learned from the DMCA and how it's kind of rolled out over the past 2 decades, and how should that make us think in thinking about all of these other kinds of intermediaries that might be doing content interventions? Dimitri.
Sorry, I'll just give one small statistic. 9 out of 10 DMCA requests that we receive against our clients are illegitimate. So.
Corinne, would you like to elaborate on that?
I'm shocked to hear that. Yeah, so actually I got into doing this work coming out of the copyright wars. Not that they're over, but I've spent a lot of time litigating DMCA issues and engaging with DMCA issues. And I think that one thing that we can learn is that the notice and takedown system will be is abused commonly. Part of that is because we don't have adequate deterrence to that under current US law, unfortunately. So one of the things to think about is when you have regulation, do you have deterrence to abuse? But in the copyright context, we don't have that. Another thing we can learn is that it is far too common that the mistakes are, or the complaints are just fraudulent, either purposefully or by accident. There are many, many trademark owners who think that copyright law and trademark are the same, and so they'll send notices, things like that, that are just legal flaws, but also can be used maliciously, deliberately, because copyright is actually one of the few areas where you can get content taken offline very fast. All you have to do is send a DMCA complaint, and the service provider has every incentive to take it down. In most other areas, at least under US law, you need a court order. You can't just send an email or fill out a web form and actually have content taken off the internet. I've been at conferences where people have said, yeah, my legal counsel told me, don't do it that way. That'll be hard. Just send a DMCA notice and then the content will be taken offline. Doesn't matter whether it's copyrighted or not. So I think, it's very clear that is true. The one thing I would say, and I think this is relevant to some of the Section 230 issues that we've been talking about over the past couple of days, which is that this DMCA safe harbors did create certainty, a certain degree of legal certainty for services. And that made it possible for lots of services that exist today to exist. Previously to the DMCA, you would have had to either go get permission from Hollywood or risk ruinous legal liability if you guessed wrong in terms of how a court would determine whether a given use was a fair use, for example. That's been really, really important for the growth of the internet. Now, a lot of people don't like the internet these days, but when they say they don't like the internet, what they really mean is they don't like social media, which is fine. But there's lots and lots of other services that rely on the DMCA, just like they rely on Section 230. And we do like those services. If you like to call your family in another country for free or really easily. Some of us are old enough to remember when that was really hard. Now it's a lot easier. That's the internet. That's the DMCA, among other things. So I'll stop there.
Great, thank you. I know we are running very short on time, but I did want to just ask if any panelists can share some thoughts on how the Supreme Court cases, that especially the net choice cases that we all expect will be granted cert by the Supreme Court, but could be proven wrong on that. How might they affect all of these conversations that we've just been having going forward? If social media sites are prohibited by law in Texas from taking down speech that is not illegal, what could we expect next? Blake?
Yeah, so I think these cases, it's hard to start gnashing our teeth about the meaning of them without knowing how they're going to come out. And I think, one of the hard things to reconcile is the old guard kind of conservative, both political and judicial orthodoxy, I think, on these ideas was that interfering with the discretion of a private company to discriminate, even as far down the stack as an internet service provider, was an unthinkable sort of intrusion on the economic rights of a private company, and on their First Amendment rights. And I also think it's interesting with the takeover of Twitter by Elon Musk and his sort of overt alliance and embrace of the alt-right and all of that sort of thing, in thinking about actually a lot of the problems that he is trying to contend with to shore up Twitter's revenue are going to be a lot harder if they are illegal under a common carriage law. If you can't deal with bots, if you can't kick bots off the service, or all of the other sorts of things that he claims are plaguing it. So I think it's going to be a real litmus test, both these cases, for the conservative wing of the court about how strong those commitments to, corporate power used to be, and whether they've sort of changed their minds about that, and precisely how that is going to be affected. Gosh, I mean, I think on the other hand, if they all decide to go the other direction and say, well, the Texas and Florida laws are fine, all bets are off, I think we're in for a messy couple of years as the froth of enforcement and how are these laws are going to be enforced against which platforms, by whom, for what reasons, susses out, and cases wind through the courts, and platforms do jurisdiction shopping to avoid them, and there's all sorts of other issues the court doesn't have before it, 230 preemption and dormant commerce clause issues and that kind of thing. So I think if the court opens the door for these sort of common carriage laws further down the stack, we are in for a messy, I should be more realistic, we're in for a messy next decade as that all gets shaken out.
Well, that's a note to end on, and I'm realizing we didn't even get a chance to talk about the very farthest end of the stack and the advocacy that many of the folks on this call have done for net neutrality laws, and some of the fun tensions there. But I think we'll have to leave that for another conversation, maybe another FOSO next year. But thank you so much, Blake, Corinne, Dimitri, Yosef, for joining us today and for this excellent discussion. We could have gone on for another hour at least, I think. I also want to thank all of our panelists and speakers today and over the past few days for helping us have such thoughtful conversations about what the future of speech online is really shaping up to be. I want to give a special thank you to our co-sponsors for this event, the Stand Together Trust, for their support for this and all of our previous FOSO events. I also want to recognize our fantastic live captioner who's covered all 7.5 hours of FOSO for us on her own. This was a lot of legal and policy jargon, so thank you so much. And a big thank you to the entire team at CDT for their efforts in putting this whole event together, with a special shout out to Jamal Magby, who truly makes this entire process run. We will have all of the recordings from this year's Future of Speech Online posted to CDT's YouTube page, youtube.com/senddemtech. Days 1 and 2 are already available, so be sure to check them out if you missed those conversations. And thank you to all of you for joining us for the 3 days of this event. We hope you enjoyed it, and we look forward to seeing you again next year. Take care.